Hey Jeff, can you tell me more about when I would have a claim for medical malpractice?
Sure. I'm glad you asked that question because of all the phone calls that I get from potential new clients, I would say that medical malpractice questions are the most common. But that being said, for every 10 calls that I get about a medical malpractice claim, only one or two of them actually are meritorious or good claims. And let me explain to you a little bit about that. Um, a lot of times I'll get people calling me because they are very upset with their doctor because the doctor has poor bedside manner, doesn't answer questions, tries to rush them in and out of the office. So when the doctor leaves, the patient is sitting there just kind of wondering what the heck happened. What did he just say? They don't get all of their questions answered. And so that makes patients more inclined to want to seek out a lawyer when they are unhappy with how they've been treated by the doctor. On the opposite point, the opposite side of that is that doctors who have very good bedside manner, who spend whatever amount of time it takes to spend with the patient to make sure the patient understands exactly what's going on with their injuries. Those patients are more likely to give the doctor a break if they don't get a good result. And people will be more inclined to understand that, sometimes you don't get a good result in medicine. It's not a perfect science. You can do the same back surgery on two different people, and one of them is perfectly fine and the other one has problems forever. But if the doctor is willing to sit down and explain these things, I have found that patients are less inclined to want to sue that doctor. There's a couple of things to know, and the reason why we don't take most of the medical malpractice claims that call in is because, number one, these cases are extremely expensive and time consuming to pursue. And so if you have some sort of medical malpractice that does not involve a very serious permanent type of injury, then a lot of times it's not worth it to the lawyer to pursue the claim because the lawyer can easily spend hundreds of thousands of dollars in costs taking a medical malpractice claim to trial. And no good lawyer is going to to spend that kind of money on a case if the case is only worth 50 grand, 100 grand, 200 grand. So typically, medical malpractice attorneys are looking for serious and significant and permanent type of damages before they'll agree to take a case. The other thing to know is that there's a 2-year statute of limitations from the date of the malpractice. And there are some exceptions to that, but generally it's 2 years from the date that the malpractice was committed. And then your lawyer will also have to get an affidavit before you can even file a medical malpractice claim. Your lawyer will have to get an affidavit from a doctor in the same specialty as the doctor you want to sue. And that affidavit needs to say basically that the doctor breached the standard of care. And so it's expensive to hire those kinds of experts, and it also takes time. So if you believe there's been medical malpractice, it's very important that you call an attorney as soon as possible and let them start working on it because that 2-year statute of limitations can come up real quickly. And once that expires, your claim is barred forever. Now, one of the other things, the last thing I wanted to mention, Florida law years ago changed in an effort to protect insurance companies and doctors. And I've gotten many calls this year from potential clients whose mom or dad died as a result of malpractice. When there's a wrongful death in Florida that's caused by medical malpractice, you do not have a claim if you died without a spouse, you weren't married, and you don't have any minor children, which for medical malpractice means children under the age of 25. So essentially, if you're 40 years old and your 75-year-old mother or father passed away as a result of malpractice, um, and your mom was or dad were not married at the time um, of their death, and there's no children, your mom and dad don't have any children under the age of 25, you essentially have no claim for medical malpractice, which is just hard to fathom. And when I tell people that, they really can't understand it. And I don't really understand it either. It doesn't make sense to me, but that's the way the law is. So there are a lot of very peculiar and unusual laws that apply in medical malpractice and things that sometimes go against common sense. So I would recommend that anytime you have a potential malpractice claim that you call a lawyer, a medical malpractice lawyer, as soon as possible to get answers to your questions and see whether or not you have a good claim.